All right. Good morning, ladies and gentlemen. I'm Judge Michael Davis. Morning, Mr. Romero. You're all here.
Good morning, Judge.
Good morning. You're all here because you've been arrested. This is the first appearance court. And under the laws of the state of Florida, you have the right to see a neutral judge within 24 hours of your arrest. Today is not going to be your trial. I'm not going to be deciding guilt or innocence today. What I will determine is whether or not there was probable cause to arrest you. And if so, I'll set a reasonable bond in your case if it's applicable under the law. Now, you have the right to remain silent. Anything that you say can and will be used against you, and anything that you are saying is being recorded. So I encourage you not to talk about the facts of your case today. What you may be asked to talk about are things like your family and community ties and your ability to post a monetary bond. You also have the right to counsel. If you find a private attorney and they're not here, please let me know and I will attempt to contact them. You also can utilize the public defender's office. There's a representative there with you in the main jail, and there's one here with me in my courtroom. I'm going to call up the case of Christopher Evans. This was reset from yesterday. He's way down, page 20. Page 20.
Mr. Evans is here, Judge?
Great.
And me?
All right. Good morning, Mr. Evans.
Good morning, Your Honor.
All right. Your attorney is here. Counsel, if you could just put your hands on the record.
Hey, Chris, this is David Kabillion on behalf of Chris Evans.
And, Your Honor, if I may, we reset this matter so I could have an opportunity to speak to the alleged victim. I did. I spoke with Mr. Kavillion yesterday. I was advised by the alleged victim. She has no issue with this court issuing a bond. The state is not seeking a no bond hold. I was advised by my assistant yesterday that Mr. Evans has no criminal record. Mr. Kavillion provided me some information about Mr. Evans. He's got a good job. He's got family ties. So, Your Honor, we agreed to a $6,500 bond on one, $1,000 bond on two, for a total bond of $7,500 and no victim contact.
All right. I'll ratify that agreement. Is that your understanding, Counsel?
That it was a stipulation. And if I could just say something to Chris.
Go ahead.
You're going to be getting out today, okay?
Okay.
All right. So I'm going to find probable cause for the offenses. Bond to be a total of $7,500. Sir, you're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. You understand that?
Yes, Your Honor.
All right. Best of luck to you, sir. Thank you, Mr. Kabillion, for coming
Chris,
in.
we'll talk later.
All right. Take care. All right. Jordan Pierre. Page 14.
Judge, Mr. Pierre is present. He advises he has private counsel.
Yes, his attorney is here. Good morning, Mr. Pierre.
Good morning, Mr. Mayor. My name is Keith Seltzer. Okay, your cousins asked me to come in this morning and appear on your behalf. You understand?
Yeah, I understand.
All right, you're able to hear everything Mr. Seltzer's saying?
Yes, sir.
All right, if you have an issue, let us know. All right, sir, you've been charged with an armed burglary. Mr. Seltzer, have you had an opportunity to review the probable cause
Yes,
affidavit?
Judge, I've reviewed the affidavit.
All right, any arguments as to the probable cause?
Judge, my only argument would be that there doesn't appear to be any evidence that Mr. Pierre ever entered the residence. What it appears is that he's in possession of property that was stolen from the residence on that particular date. And there's an allegation that there was a number of text messages. They allege 61 text messages between a girlfriend that they allege lives with Mr. Pierre named Cassandra Sinisu, who apparently was in some type of relationship with the alleged victim.
Well, that's an interesting point, Mr. Linder.
Your Honor, I would argue that there is a presumption that possession of recently stolen property, there is a presumption that the person in possession of recently stolen property committed the burglary. Your Honor, I would argue that there is probable cause based on, and I can inform the court, when Mr. Pierre was originally arrested, he was arrested for the grand theft firearm, of the possession of firearms that are mentioned in this report. And they do appear to be the same firearms that were stolen. There appears to have been contact between Mr. Pierre and his co-defendant during the time of the burglary. So,
Mr. Pierre, let me tell you, Mr. Seltzer is making a very good argument on your behalf. There's nothing in this probable cause affidavit that says or can place you at the scene in this case. However, according to the probable cause affidavit, several hours after the alleged crime was to have been committed, you were stopped allegedly in possession of these firearms, which were stolen from the victim's home. There is, under the law, a presumption, if it's close in time, as Mr. Linder pointed out, to connect you possibly to that burglary. So for a probable cause finding, which is a very, very low legal standard, and this is just the beginning of the process, I'm going to make a probable cause finding with the understanding, again, that that's a very low legal standard in a non-adversarial hearing. Now, is the state seeking a foreclosed bond in this case?
Your Honor, we are seeking a no bond hold on this count. I can advise the court at the time this offense was allegedly committed, Mr. Pierre was out on bond on two felonies, felony possession of marijuana and a burglary conveyance and petty theft.
Mr. Seltzer?
Judge, I can only tell the court that yesterday detectives from the sheriff's office showed up at Mr. Pierre's residence seeking to arrest him. He was not there. A relative contacted me. I reached out to Detective Sokol from the sheriff's office and made arrangements for him to surrender on the charge. He's a lifelong resident of Broward County. He's only 20 years old. He did voluntarily surrender, knowing what the nature was of this charge and even the possibility that he could be held without bail. So I ask that you consider that, and considering whether there's some conditions of bond being in excess of a high bond plus electronic monitoring and pretrial would suffice to ensure his appearance in court for the
Well, sir, I can tell you Mr. Seltzer's a fine attorney. He has appeared before me before, and I've always been impressed by his arguments and by his manner, and I suggest that you listen to any advice that he gives you. For today, I'm going to hold you without a monetary bond based on this offense, and that'll be pending a full evidentiary hearing before your division judge.
And I'm sorry, Judge, could you please, I don't want to, could you please ask, I don't know if that noise is coming from main jail.
We've got quite a bit of background conversation here. It's going to be hard for Mr. Pierre to hear. If we could just cut down on the chatter a bit, I'd appreciate it.
Thank you, Judge.
All right, I will leave it up to the state if they're seeking revocation on any of the other cases to do that in this division. Sir, you're going to have no contact with the alleged victim in the case. Don't call, text, write, email, or try to find him on social media. Stay at least 500 feet away. Do you understand?
Yes, sir.
All right, best of luck.
And Your Honor, just one, we'd ask for no victim contact.
Yes, that I issued.
Oh, I'm sorry. Sorry, apologies. And two, a matter I discussed with Mr. Seltzer before Your Honor took the bench. I just want to put on the record, it's the state's position. The court's findings only apply to this first appearance. I imagine Mr. Seltzer will be seeking an Arthur hearing in division, and none of the court's findings today, that court is not bound by any of the court's findings today.
Absolutely, that's correct. And you'll have an opportunity before your circuit division judge to seek a bond. All right?
Mr. Pierre, do you understand the court is not revoking your other bonds, but they are holding you no bond on this armed burglary charge because it's what's known as a life felony, and generally it carries no bail until there's a matter addressed by your assigned judge at what's known as an Arthur hearing. You understand that this morning?
Yes, I do.
Okay, good. All right, I'll be in touch with you.
All right, good luck. Good luck.
Okay.
Thank you. All right, always a pleasure. You look great. You look great. All right. Good morning. How are you? Paul Costello, right?
Yes, Judge. Page 13 is Paul Costello.
Very good.
Jim Lewis on his behalf, Your Honor.
All right. Thank you, Mr. Lewis. Good to see you.
Good to see you.
Mr. Costello, your attorney's here present? Mr. Lewis.
And I just need just one moment. The state just provided me with
Your
a.
Honor, the PC that was attached was missing a couple pages.
Yeah, 13.
Do you work? For the zero? Do you work? For the zero? You did the two things from the government, so security have a point of reference now. Do you own any property, like you? Any money? How much? Circle these numbers and these numbers individually pressed down horizontal. No, sir. Those are already done.
All right. I've reviewed the probable cause affidavit. So the charges are aggravated battery with a deadly weapon, a battery And there's also 2 misdemeanor warrants you're being held on. One is a charge of possession of controlled substance. The second is a charge of possession of paraphernalia. Now, I'm going to ask your attorney. Today, my job is to determine whether or not there's probable cause to arrest you. It's a very low legal standard. This is a non-adversarial proceeding. I'm relying only on the police report that's been given to me. Mr. Lewis, do you have any arguments as to probable cause?
Yeah, not as the probable cause, Judge.
Okay. All right. So I'm going to find probable cause. Again, it's a very low legal standard. Now I'm going to ask Mr. Lewis as to the bonds.
Judge, I had been on this case back in October. When Mr. Costello came in and saw me and hired me, we contacted the Hollywood Police Department and offered to surrender. There were no charges pending at that time. My understanding is the parties have reconciled. They lived together for a 3-year period of time, so that there will be an affidavit forthcoming asking the state not to go forward. But as I understand it, the court can certainly read to domestic and shoot involving scissors, the cutting of hair. But again, he's been around. He hasn't gone anywhere. We were just unaware that the charges had been filed and the non in custody. He's lived here all his life. He has steady employment. I've asked the court to consider like a $2,500 bond on the aggravated battery offense. And again, we knew these were we didn't know they were coming, but we were aware of the allegations. We contacted the police in order to surrender, and nobody ever got back with us.
Okay. Mr. Linder?
Your Honor, the only thing I've seen as far as criminal history, he's had some possessions of marijuana. I saw one out of Texas, one out of Broward, one out of Dade, but nothing else.
And let me ask the victim advocate, have you had any contact with the
I
victim?
spoke to one of the victims. She didn't have anything to say. She just wanted to know the outcomes.
Mr. Lewis, you said so they've been living together since...
That's my understanding. I don't know if they're living together, but they're friendly.
They're friendly. Okay, so they're reconciled.
They're still dating.
Okay, all right, I understand. Okay, they're not residing in the same residence, but they're friendly. Okay. All right, so what you suggested a $2,500 bond on the aggravated battery?
Yes, sir.
I'm comfortable with that. I'll set a $2,500 bond on the aggravated battery. I'll ROR count 2.
Andrew sentence?
Now he understands he's got these capias. He's going to have to. You'll make sure he gets back to court.
We'll get to court on those
All right, then I'll
city
ROR
ordinances.
counts 3 and 4. It'll be a $2,500 total bond. What I'm going to do in an abundance of caution, I'm going to issue a no contact order, but I'll allow phone contact, so no in-person contact at this time with the victim in this case. So you're going to stay 500 feet away from her, but I will allow phone contact. So you got a $2,500 total bond. He does have a status hearing coming up on the misdemeanors. Yeah, the 16th. Do you want me to keep that on, or you want a different date?
Is that on the misdemeanors?
It's on the misdemeanors.
It was on the
telling me
case in
Division
front of Judge
MN.
Cohen. Okay, that's fine. We'll keep it on. We'll find it.
Okay, that's at 10 a.m. All right, very good. Nice to see you, Mr. Lewis.
Thank you,
All right,
Judge.
good luck to you, Mr.
Appreciate it.
Costello.
You get out.
Thank you.
All righty. All right. And we got one more attorney here who just walked in. What,
Down the middle outside.
counsel, what case are you here on?
Bow, yeah, T-H-A-U.
Bow?
Jenna Bow, yes.
Jenna Fab? Okay. Jenna Fab. Page 5.
Jenna Town? Come on up. Your counsel's here present.
All right, Ms. Thao, good morning. I'm Judge Davis, and your attorney is here for you as well. If you could put your appearance on the record, counsel.
Colombo for the defendant, for the record.
Very good. All right, ma'am, you're being held on a violation of your felony probation. That probation is being supervised by Judge Bailey. I'm assuming it's Dennis Bailey. You're going to be held without bond at this time by his order, but you do have a violation of probation date set before him for February 14th at 8:30 a.m. Your attorney will be there on your behalf, and you'll be able to address that charge. Do you understand?
I do.
Counsel, anything else?
That's it, and then I'll be out to see you before that, okay? She able?
I just didn't hear her.
I'll be out to see you before the 14th.
Okay, thank you.
Your lawyer's going to come see you. All right. Thank you so much for coming in.
Thank you very
Nice
much.
to see
Thank
you.
you.
All right. Good luck. All right. Now we'll start back on page 1. Jessica Elias.
Tanisha? I know you just,
All right.
is this just an ad charge on count 2? Because I didn't count 1 we already handled just the other day.
Right. That was, I found a criminal mischief. Yeah.
Yeah.
So did they just... Oh, I see. All right. Well, Ms. Elias, good morning again. Nothing has changes. This is sort of a procedural hearing. I am finding probable cause for criminal mischief, still setting that $100 bond, and you've got the violation of probation or community control. Like I said the other day, have no contact with the alleged victim. You stay 500 feet away from him. Don't call, text, write, email, or try to find him on social media, okay?
Yes, sir.
All right.
I already posted the bond. For the charge, for the battery charge. So I'm basically waiting for Miami to come and pick me up.
For Miami to come pick you up, exactly.
Okay,
All right.
thank you, sir.
All right, good luck to you.
Have a good one.
Good luck, Mr.
Thank you.
Yeah, might as well do it. It's a new magistrate hearing. All right, Nixon Talusma.
Your Honor, if we could place this on a brief recall, witnesses coming.
All right. I've been asked to recall this case. We're waiting on a witness, so I'm going to do that. Mr. Talusma, we'll call you back up in a few minutes, okay? All right. George Cotton.
Yes, sir.
All right. Good morning, Mr. Cotton. You're charged with domestic violence battery. I'm going to find probable cause for that offense. Advocate, have you had any contact with this victim?
No, Your Honor.
All right. Mr. Linder, any priors?
Your Honor, I'm showing he was arrested last year for aggravated battery. And that was against the same alleged victim. The charge was dropped.
All right. Mr. Romero?
Judge, and speaking with Mr. Khan, he's been residing here in South Florida for 4 years. He is from Gainesville, Florida. He's currently employed. He works for the animal clinic located on Ives-Airy Road. He's a veterinarian technician. He's been working with that company for about 2.5 years. He makes approximately $13.50 an hour. Financially, he has no money in the bank. He owns one motorhome, and the alleged victim, his wife, that's where she'll be staying. I told him most likely on a domestic situation, Your Honor, will be imposing a no-contact order. He has no problems abiding by that order. He will live separate and apart from the alleged victim with a friend. Judge, we'd be asking you to set a reasonable bond considering he has no prior convictions and his ties to the community, Judge.
All right, Mr. Cotton, I'm going to set a $3,500 bond on count 1. You're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand that?
Yes, sir.
All right, good
Judge,
luck to
one
you.
request.
Yes.
All his belongings right now are located at the motorhome. Can he go one time with law enforcement to retrieve his property?
Yes, that'll be fine. Good luck.
Thank you, Judge.
Lionel Perry.
Mr. Perry, come on up.
All right, Mr. Perry, you're charged with domestic violence battery. I'm going to find probable cause for that offense. Victim advocate, have you had any contact with the victim?
I did, Your Honor.
tell you in a
She
second what
stated that she
happened.
was trying to get her belongings together so that she could leave.
So that she can leave. Okay. Mr. Linder, any priors?
One moment, Judge. I have his record here. Okay, out of Maryland, 1994, battery. I'm sorry, the battery is null pros. He pled out to a possession of controlled substance. He had a battery in Maryland, 1987. End of record.
All right, Mr. Romero.
Judge, Mr. Perry has been residing in our community for the past 4 years. At this point, he's unemployed. He's collecting disability. He gets approximately $1,500 a month. He owns no property. Judge, we'd be asking you to impose a reasonable bond as to Mr. Perry.
All right, Mr. Perry, I'm going to set a $2,500 bond in this case. You're going to have no contact with the listed victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. Do you understand?
Yes.
All right, good luck to you, sir. Brandon Dudley.
Mr. Dudley's here present.
All right, good morning, Mr. Dudley. You're charged with domestic battery by strangulation. false imprisonment of an adult, and you're being held on 4 felony warrants. I'm going to find probable cause for the new offenses. Advocate, have you had contact with the victim?
No, Your Honor.
Mr. Linder, I see the warrants. I see the charges. Any other priors?
Checking that right now. Your Honor, I'm showing unlawful use of false name ID 2014, resisting without violence 2011, resisting without violence 2010, 2009 felony credit card fraud and theft. He violated probation. Unlawful use of false name identity 09. And there was a robbery by sudden snatching arrest in 08 that was dropped.
All right, Mr. Romero.
Judge, as being Mr. Dudley, he's 26 years old. He's been residing here in South Florida his whole life. He's currently employed. He works for a company called Field Auction Service. He's a remover. He's worked for that company for about 2 years, making approximately $12 an hour. Financially, has no money in the bank, no property. Judge, he will be living separate and apart from the alleged victim. He'll be living in Pompano. I know they share a child in common who's 2 years old. We'd be asking you to sign an order allowing for contact to be made via a third person to arrange for child care and visitation. Also, he has a separate child from another, from his ex-girlfriend. He actually pays child support and $600 a month. We'd ask you to take that into consideration and impose a reasonable bond as to counts 1 and count 2.
Okay. All right, I'm going to set a $10,000 bond at count 1, a $5,000 bond at count 2. There is no bond on the felony warrants. That's counts 3, 4, 5, and 6. You do have a court date coming up with Judge Bailey. I'm assuming it's Dennis Bailey, on February 14th at 8:30 a.m. At this time, you're going to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. And you'll have to go through a third party to have visitation with the minor child. All right, good luck to you, sir.
Thank you.
Sidel Vilsenor?
Not right now.
Judge, I have probable cause. I was going to argue it's an assault.
Assault?
Yeah.
Mr. Linder?
One moment, Your Honor. Well, actually, Your Honor, if I could just have one moment.
All right, let me tell you, Mr. Vilsenor, you're charged with an aggravated battery with a deadly weapon, and your attorney's making an argument about that charge. We're just having some legal discussion at this time.
Your Honor, I'm fine with that. I just want to state my issue, and I think what this will come down to, reading the definition of aggravated battery. A person commits aggravated battery when committing battery uses a deadly weapon, and the allegation is he had his hand on his throat committing a battery when he armed himself with a knife. So I guess it'll come down to whether holding a knife while committing the battery is enough to satisfy using, but I'll leave that for another day, Your Honor, and I'm fine with probable cause for aggravated assault.
All right, so I will find probable cause for aggravated assault rather than aggravated battery. I've noted that on the sheet here. What are Mr. Vilsenor's priors, if any?
One moment, Your Honor. Your Honor, he was arrested last year for domestic violence battery against a different alleged victim. That charge was, Your Honor, the charge was dropped. And frankly, and I know that the court's familiar, I'm just making a record. My concern is, allegedly, Mr. Vilsenor stated while he was in possession of the knife, "This is the day." that could certainly be interpreted and to mean that very serious harm was considered to be, it was contemplated against the alleged victim. So that is a cause for some concern, Judge.
All right, Mr. Romero?
Yes, sir. Judge, in speaking with Mr. Vilsanor, he's been residing in our community his whole life. At this point, he's unemployed. Right now, he's trying to go back to Broward College. He's studying nursing. He's going to start his second semester. Judge, at this point, he has no money in the bank, no property. The alleged victim is his brother. I know him and his brother stay with his parents. His parents are his whole financial caregivers. They support Mr. Vilsanor until he graduates and he's
Should be an Odyssey.
and he is able to support himself in his career. So at this point, he has really no sort of financial resources. He personally is indigent. We'd ask you to take that into consideration and impose a reasonable bond.
All right, sir. I'm going to set a $10,000 bond in this case. You're to have no contact with the alleged victim, your brother. You're going to stay 500 feet away. You can't call, text, write, email, or try to find him on social media. Do you understand that? All right. Good luck to you, sir.
And Judge, we're going to need a photo order.
Sure.
Thank you.
And Your Honor, just to advise the court, the witness on Mr. Thalusma's case is now present.
Okay, great. So I'll call that case
Judge,
back North Broward, yes.
There may be some discussions of some mental health issues. I would ask the court to discuss that sidebar.
Okay,
I already
sure.
spoke with him, but if we're going to get into that, I don't want that streaming online.
No problem at all. All right. Good morning, Mr. Thalusma. You're charged with violation of your pretrial release conditions for domestic violence. I'm going to find probable cause for that offense. Ma'am, what's your name?
My name's Kathleen Delusma.
Okay. How are you related to Mr. Nix?
This is my older brother.
Your older brother.
Yeah, I came actually to let you know, he's been diagnosed mentally handicapped.
Hang on one second. I'm just going to hit a button here. I don't want this stream. Mr. Delusma, go ahead and have a seat again. Your sister's got to make a phone call, and I'll call your case back up, okay? All right. All right, Jody McDonald.
That's a North Broward medical reset, Your Honor.
Med reset? Okay. This will be for Saturday morning. By the way, Mr. Opsahl, I did confirm for you, Judge Lerner will be here tomorrow. Just so you know. Erica Abraham.
North Broward, Your Honor.
All right. All right.
Judge?
Yes.
I think the issue is, doesn't say who the witness was. Did they give a sworn statement to the officer? Borderline with regards to the PC.
Mr.
Frankly, Your Honor, one moment. Miss Abraham is being held on, I think, well over $100,000 worth of bond.
Yeah.
Whatever the court wants to do. I'm not going to argue over criminal misdemeanor.
I'll find no probable cause and release her on a recognizance on the charge. All right. Good luck, Miss Abraham. You're released on this charge only. Good luck. Oh, I'm sorry, Mr. McLawrence. I didn't see any for you.
There are two, Judge.
Two? Okay.
Yes, good morning, Your Honor. On page 9 of the docket, there's a Todd Stone. He's in the main jail. Judge, I didn't get the opportunity to speak to either of these two individuals, but I want the court to know that for both of these individuals that I'm going to call up, their cases, Mr. Stone's case is a 2013 case, and on page 13 there's a Paul Costello, and he has a 2011 case.
Jim Lewis came in on that case, and I asked him, he told me he's going to be representing one of the MOs also.
On the Costello?
Yeah, Judge R. Wardham on the MOs.
Yeah, right. We were right. Mr. Lewis. All right, so really it's just going to be Mr. Stone for today.
Yes, Judge.
All right, so Mr. Stone, you're being held on a warrant for petty theft. And this has got some age on it. I'm going to appoint an attorney to represent you. His name is Jared McLawrence. He's here with us today. All right, does he have any other recent priors, Mr. Linder?
I just need his BCCI number, Judge.
690-617?
690-167?
No, 690-617.
That was close.
Yep, very close.
His last arrest in Broward was 2011.
All right. And if he wants to withhold in court costs, we can do that today.
Okay. Mr. Stone, the court is offering you a withhold in court costs, which means that the case would be over today. You wouldn't have to come back. But I also need to let you know that because of the age of your case, you may qualify for a motion to dismiss these charges against you, because I didn't see anything from the record that showed that any effort was made to ever serve you on this matter. But of course, that would mean that you would have to come back to court. So it's up to you whether you want to resolve it today with the withhold on court costs, or whether you want me to ask the judge to release you on your own recognizance, and you have to come back to court so I can fight it on your behalf.
Well, yes, sir. After that 2011, I went through a year-long rehab, and I never heard anything, and I thought the case was resolved. I thought the rehabilitation for the year I was there took care of it.
Do you have a residence now, Mr. Stone?
Yes, sir, I do.
Judge, I was going to ask if you would release him on his own recognizance.
That's fine. I'll release on recognizance. Now there's no court date yet. They didn't set one yet on this. So,
Judge, who's the PD in the main jail?
Hector Romero.
Judge, I just wanted to give Mr. Stone my number. Hector, can I give you my number so you can give to him for me, please?
I sure can. What is it?
It's 954-318-1376.
Okay. This is Charles McLawrence, excellent attorney. He'll be representing you. Okay? Give him a call when you get
thank you, Mr. Lawrence. Have a good weekend. We're only doing a morning. I shoved everything in the morning this morning, so I'll see you next week. All right. Ma'am, do you want me to call?
You're done?
Okay. All right. Good. All right. So let me go back to the North Broward. We can call Mr. Thaluzma back up. So you're you're Nixon's father, and you're Nixon's brother? All right, great. So we're having some discussions with your sister, your daughter. So Mr. Thaluzma, Sr., I'm a little worried about Nixon coming back to live in the house. Do you speak English? A little bit? Okay. Well, I'm a little worried for your wife because of what happened the other day. You know what I mean? What's your name, sir? Kristen. Do you live separate from your parents? Can Nixon come and stay with you for a little while? How are we going to get Nixon to understand that he can't go back to your parents' house for a while? If your siblings, explain it to him, will he understand? Okay.
The burden will be on my mother because she, as a mom, she always wanted him to be close to me. But we always tell her that, because of his state of mind, that he has to give him his independence.
Right.
Because sometimes you want to do something, but my mom, my mother, she always wanted to keep him
Close.
tight.
Right.
And especially with his mental disabilities.
Right.
So she's always had him as her.
Every time I has to work with mood swing, that's when he's been living in the house for more than a year now, and nothing ever happened. But that last time his mood was, he had mood swing.
Do you speak Creole?
Huh?
Do you speak Creole?
Creole?
Creole.
Yeah.
Can you ask your dad what his opinion is in Creole, if he wants him to come back to the house or not? Or if he's scared for him and his wife?
Put your phone down.
Scott. Yeah, he said he don't really have a problem with having back.
Okay.
Not even my mom. He doesn't have a problem with that.
Right, when he gets upset.
Like I would always tell my mom, every time you see that you move slow, you gotta leave him alone. Don't stay away from him. The reason that thing happened is because my mom didn't my mom pulled his back. She was aware that he's in a mood swing, and then you should have help.
Do you live in the house?
Yeah, I do.
You live in the house. So it's you and your parents and your brother.
Yeah.
And then you have another. You live with your family. Okay. But do you visit?
Yeah.
You live close by?
No.
All right. That's good. All right. I'll allow Nixon to go back home. So I'll dissolve the no contact order in both cases.
Your Honor, the state would object.
I understand.
I know, but I have to make a record in case something happens, because we've heard testimony today. His own sister was talking about he should be Baker acted, which tells me he could be a danger to himself or others. We have heard testimony, for instance, when he's having a mood swing, his mom needs to stay away from him, which tells me there's self-control issues. What if there's an argument about something else? He can't control himself. To Your Honor, I think this could potentially be very dangerous, allowing him to be around his mother right now. And I need to make a record, because if something happens, we've been told there's another residence that he doesn't have to be around his mother. His brother even said he can explain it to him to have no contact. I don't see, we have alternatives. I don't see a reason why contact has to be allowed at this point.
Judge.
For the moment, my mom concerned, she will allow, I think she wants us to find a place. That's what we should do. But the last time I spoke to her, he used to go to a program, but my mom stopped him from going to the program. So when he got his independence, my mom had to give him his independence. So last time I spoke with my mom after that happened, she told me that she's going to let him go to the program, give him his independence, that's you want. So that's the last conversation that I had.
How about this? Can he go and live with you for a little while? Kristen, while you try to find him a program. And he can see his mom only with you. So if he wants to see mom, you're there, he's there, mom's there. So that way, he doesn't have to be apart from his mother. He can see his mother because for someone with, issues like you're telling me, he has consistency and family are very important. But maybe he shouldn't see mom by himself, only in your presence. So supervised. You'll be there to supervise. And when things are getting hot, you say, "Okay, Nixon, time to go." Think that's doable? Dad? I see Dad's shaking his head. You like that? Thumbs up to that? You understand? Okay. And then that way the family can try to find Nixon a place to go.
Yeah.
He doesn't have to be apart from mom. He can still see mom.
But under supervised.
Under supervised, right? Exactly. And he can live with you for a little while. And hopefully you can find him a place. And I'm going to appoint the public defender's office. Yeah. So we'll do it on both cases, yeah. And I'll release him today without a monetary bond. He's going to have to live with you. And
Your Honor, and just so we're clear, I'm going to ask that the supervision, if there's contact, the supervision has to be with his brother. I mean, no offense.
No,
but,
that's what I said.
I know it was that supervision. I just want to make sure there's no confusion that the supervision will be with the sister or the father, because, no offense, if something happens, I don't know if they'd physically be able to stop it.
I know. That's why I'm ordering it with you, sir. You can both be there, too, of course, if you want, but I need to have you there. And if things start getting hot, you can say, "Okay, Nixon, let's go. Time to go back to my house or take a walk or something like that." And you're all going to work on trying to get him a place. And I think that the public defender will try to get these cases transferred over to the mental health court, which is the place that it really needs to be.
Before Judge Cohen, because it's domestic in nature.
Oh, he keeps his own.
Keeps
right?
his own domestic.
All right. So this will be before Judge Cohen, who's a very caring judge, and that's what we're going to do at this point. Okay? You all come to the family all comfortable with this?
Yes, thank you, Judge.
All right, good. All right, so Nixon, you're going to be released from jail today. You're going to go live with your brother for a little while. Friston, right? Frisnell. Okay, Frisnell. You're going to go live with Frisnell for a little while. And when you want to see your mom, Frisnell's going to be there with you. Okay? All right. Good luck. Thank you all. Yes. Exactly.
And that he must reside with the brother also.
Right, he's got to reside with us. He's going to reside at his brother's home. Okay. All right, well, thank you all for coming in to see me today. Thank you very much. Very nice to meet you all. All right, good luck. All right, let me see. We got a number of other municipal ordinances today. Let me just text Mr. Shade. And for now, I'll skip. Oh, wait a minute. That's not a municipal. Destiny Williams?
Ms. Williams is here present, Judge at Maine.
All right.
Do you have any children?
All right, Ms. Williams, you're charged with grand theft auto and petty theft in the first degree. I'm going to find probable cause for those offenses. I'll release count 2, set a bond of $1,000 on count 1. Yeah.
Thank you, Judge.
You want to post a $1,000 bond, or do you want to go out on pretrial release conditions?
Can I ask her?
Sure. All right.
Judge, Ms. Williams would appreciate pretrial.
All right, so ma'am, I'm going to release you to custody of pretrial. You're going to have to register with them today, and you'll have to follow all their conditions, okay?
This is the map to pretrial when you get released. Here's the map. It's
Yeah, for
across
both
the
counts. I'm
street.
taking off the ROR. It's going to be both counts on pretrial. All right.
It's across the street. Okay, this is the map. You go there today when you're released. Have a seat.
All right, good luck, Miss Williams. Yes. Oh, all right, Mr. Romero.
Yes.
Do you mind bringing her back real quick?
Oh, Miss Williams, come on up.
Part of the condition of the pretrial is you're going to have to go to school daily because you're a student. You understand that?
Yes, sir.
All right. All right. So if you violate that, if you cut, that could be a violation of a pretrial. Got it?
Yes, sir.
All right. Good luck.
All righty.
Danielle Vecchio.
North Broward.
I'll take care of it. Yeah. Is that Okay, Miss Vecchio, you're charged with petty theft from a merchant, a second offense, possession of a forged driver's license, and 2 counts violation. Oh, wait, where is she? She's in North Broward? Oh, there we go. Sorry about that. All right, let's try this again. You're charged with a petty theft from a merchant, second offense, possession of a forged driver's license or ID, and 2 counts of violating your probation or community control. I'm going to find probable cause. There's no monetary charge on count 1. It's a $1,000 bond on count 2, and there's no bond on counts 3 and 4. After you resolve the Broward cases, they'll bring you to Palm Beach to address the violations. Good luck, Ms. Vecchio.
Thank you.
All right, I'm going to skip down to page 15. There's one more domestic case. That's Desmond Perry.
Did you call up Miss McDaniel, Judge?
No, I'm skipping Miss McDaniel now because there's a domestic case with a witness that's on page 15. It's Desmond Perry.
No, I need her.
Okay. All right, Mr. Perry, good morning. You're charged with domestic battery by strangulation and a domestic violence battery. Ma'am, what's your name?
My name is Ann Perry.
Okay, and are you Mr. Perry's mom?
Yes.
All right, great. What do you want to tell me about him?
First of all, this incident I thought was all resolved because when this incident occurred, I went in to Pompano, where it happened, and they stated it was nothing. And far as I know, the victim, along with my son, spoke to somebody. I don't know who, but I do know someone did call to speak to him about the case. From there, I thought all of this was resolved because when I went in, when it first happened, to get information, I told them if it's anything, he would come in to turn himself in. So we assumed, which is the wrong thing to do, is assume that everything was taken care of, and found out yesterday nothing was taken care of.
Okay.
Because if he knew he had a warrant or he was going to be arrested, he would not be here today because it would have been taken care of.
Okay. Mr. Linder?
Your Honor, I'm going to print out a supplemental report. There's a lot more to this case, a lot more aggravating, aggravating allegations in this matter. I can just have one moment.
Sure. And has the victim advocate had any contact with the victim?
No, Your Honor, there was no phone number listed.
Okay.
Just one report, basically. Is there paper in there? Okay. Jammed or anything?
Were you able to get in touch with your office on that other case? Is Mr. Reyes going to come? He's going to come down?
He called me 20 minutes ago. He'll be here around that.
No rush. All right. All right. Is it on Odyssey?
No. Your Honor, I'm just going to read from it. The officer responded October 30th at approximately 9:30 in the evening. The alleged victim advised she'd been in her home sleeping in their residence. He started to wake her for work. It's alleged Mr. Perry started going through her phone, found a social network message from a male. He became enraged and yanked her up by the clothes she was wearing. A struggle ensued. He punched her in the mouth and choked her. She found it hard to breathe when she was choked. She advised she proceeded to faint. When he released her, she fell to the ground, hitting her shoulder. Her shoulder was hurt, and she had a cut on the inside of her mouth. She locked herself in the bathroom. She could hear him rack his handgun while she was in the bathroom and yelled that he was taking her $400 worth of rent money. Her cell phone and keys were also missing. One moment. Determined the firearm in question was a Glock 26. She had safety concerns because she had nowhere else to go that evening, and that he still had keys to the residence. She did provide a sworn statement. Her injuries are photographed. And basically, and obviously what I wanted to inform the court of is that anytime there's an allegation of a firearm being involved in the matter.
Okay. All right, let me hear from Mr. Romero. By the way, any priors?
Checking that right now, Your Honor.
No.
Okay.
He's never been arrested before.
All right, Mr. Romero?
Judge, and speaking of Mr. Perry, he's been residing here his whole life. He's 25 years old. He's a graduate of Boyd Anderson, class of 2010. He's currently employed. He works for Federal Express. He's been working with that company for the past year. He's making approximately $13 an hour. He lives with his separate and apart from the alleged victim. As Mom verified and Mr. Lender also verified that this is his first arrest ever. He's a registered voter. He has about $200 in the bank. He owns no property. He did advise me that he did contact BSO sometime, I believe, in early November of 2016 to actually see if there was any outstanding warrants in order to turn himself in. At that time, he was advised that there was nothing as far as a warrant. So his intent was, if he knew about a warrant, he was going to go ahead and self-surrender. Judge, we'd ask you to take into account his strong ties to the community and impose a reasonable bond as to Mr. Perry.
All right. All right, I'm going to set a $5,000 bond on count 1 and a $1,000 bond on count 2. You're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. You're to surrender any firearms and or concealed weapons permits to your local authorities, the local police department, within 24 hours of your release. Do you understand that, sir?
You understand?
All right,
Yes.
Good luck, sir. All right, thank you for coming in.
Thank you, Judge.
All right. Guys, I'm taking 2 minutes. All right. Back on the record, and I'm going to be going over to North Broward. I know you're on the phone. Yeah, no problem. Actually, you know what? I'll call another one while you're talking to him. Terrell McDaniel.
Ms. McDaniel is here, President Main Judge.
All right, great. All right, Ms. McDaniel, good morning. You've been charged with possession of cocaine, possession of drug paraphernalia, and tampering with physical evidence. I'm going to find probable cause for these offenses. Do you have any priors?
One moment, Judge. Yes, priors include 2016 prostitution, 2015 possession of PVP, 2014 theft, 2014 resisting with violence, trespass, VOP, year and a day state prison, trespass 2014, 2012 grand theft auto, unlawful use of false name ID with the VOP, end of record.
All right, Mr. Romero.
Judge, in speaking with McDaniel, she's 25 years old. She's been residing in our community her whole life. At this time, she's unemployed, but she's looking for work. She last worked, I believe, about a month ago. She cleaned a house, and she got paid for that, but it was minimal, Judge. She graduated from Dillard High School, class of 2011. Financially, she has no money in the bank, no property. She lives in Fort Lauderdale with her grandmother. She's been residing at that address her whole life. Her grandmother is retired on a fixed income, Judge. Grandmother's the only one that could possibly bond her out, but she does not think she has the financial resources to do so. We'd be asking you, if pretrial can verify, we'd be asking you to consider pretrial release, Judge.
All right, I'm going to set a $1,000 bond on count 1 and ROR counts 2 and 3. Good luck to you, ma'am.
Thank you.
Stephanie Corbett.
All right.
All right, Ms. Corbett, good morning. You're charged with unlawful possession of personal ID of another, possession of a counterfeit driver's license, robbery by sudden snatching, and a probation or community control violation.
And, Your Honor, I just want to see here. It's actually strong arm robbery. I just reviewed the information.
Okay.
Judge, I didn't get an opportunity to speak with her.
You want to call her? Or
Yeah, I'll call her.
Okay. All right, Ms. Corbett, your public defender is going to contact you. I'll recall the case. Thank you. Thank you very much.
Thank you.
You want to call her? Okay, he's calling her. Yep, he's going to call her. He's going to call you right now. All right, Sharon Shepard.
Paul Ryan.
She's at AM court, sir.
AM court. All right, so this will be a recess Saturday AM. Eric Colbert.
Judge, I've been advised medical loan.
Okay. Saturday morning. All right, I'm going to skip Mr. Hamby. Mr. Shake said he would let me know in a few minutes when he's going to be available for the municipals. Jerry Edwards.
Mr. Edwards, come on up, please.
All right, Mr. Edwards, you're being held on 3 traffic warrants. The charges are leaving the scene of an accident, operating without a valid driver's license, and a suspended driver's license. Bonds are $100 on counts 1 and 2, and $250 on count 3, sir. You got a court date, February 20th at 2 p.m. Good luck.
Judge, if we could be heard, in speaking with Mr. Edwards, he's 49 years old. He's collecting disability, approximately $735 a month. He lives with his mother in Fort Lauderdale. He believes his mom has $100 to post his bond, but nothing more besides that. He has no savings. Would you consider an ROR on counts 2 and 3?
Your Honor, he's one of the cases he left the scene. Right. It's 2 separate cases. Sometimes the bond should really just be where the judge said the bonds are.
And that's why I was asking for the $100 to remain on count 1, which is leaving the scene, and on counts 2 and 3 to ROR.
And I think it's reasonable for his judge to have the bonds that he or she said kept where they are, in light of the fact that one of the allegations, he fled, and on 2 separate dates he didn't show up on 2 separate court cases. There's really no mitigating factors that have been presented that outweigh the aggravating factors.
Well, the factor I would ask you to look into, Judge, is his financial resource. Unfortunately, he knows his mother from what he advised me, he knows that she has $100 in order to go ahead and post his bond, and that's why I'm asking for counts 2 and 3 to ROR. If he had money, I wouldn't even be making that request.
I'm looking at his traffic history. He's got quite a history of failure to appear. I'm going to keep the bonds in place. Good luck.
Yes, Judge. Thank you.
Donald Chipman.
Mr. Chipman, come on up, please.
Mr. Chipman, good morning. You're charged with You're charged with 2 counts of violation of your misdemeanor probation. Bond is $2,500 per count. You're going to see Judge Brown on February 16th at 10 a.m. to address the charges. Good luck to you, sir.
Thank you.
Rakeem Johnson.
Mr. Johnson, come on up.
All right, Mr. Johnson, you're being held on a traffic warrant. The charge is driving with a suspended license.
Judge, I know. Let me ask the judge. Judge, he's advised me that he now has a valid driver's license. If you could verify, would you consider an ROR?
Your Honor, I was actually going to use this case to rely on this case on another case later, but I'm just going to use it now. Matta v. Lamberti, Your Honor, the 4th DCA was very clear. Judge issuing capias or any judge making an order regarding bond, unless that judge clearly expresses that it may be modified, the 4th DCA has held that it cannot be modified.
Judge, you're the magistrate judge. I believe it is within your purview to determine if there's nothing written as far as that the magistrate judge or hold for that designated assigned division judge, that I believe you can modify it, Judge, based on the circumstances. In this situation, we have Mr. Johnson, who's here before you on a DWLS. He's advising me that he believes that his driver's is now valid. He's taking affirmative steps in order to rectify the situation. I'm asking if he has a valid driver's license now to consider an ROR.
And Your Honor, frankly, and respectfully, Mr. Romero doesn't have a copy of the case in front of him. I gave a copy to Mr. Ofsall, reading directly from the 4th DCA's holding. The judge setting the case did not authorize the setting or modification of bail by the judge presiding over the first appearance. Therefore, the first appearance judge had no authority to grant bail.
This is a case.
I believe then that's dealing with a no bond hold then.
That was Judge. That was the Matta case came before Judge Hurley. That was a case where there was a no bond hold on a violation of probation, where Judge Hurley set release conditions and set a bond in the case. So it was taken up by the 4th District Court of Appeals, which ruled that on that particular warrant where he was being held no bond, the judge didn't have the authority to modify the bail conditions. I've been in this division for 2 years, and I can't tell you since that case. In that case, everybody's aware of. The court has been resolving misdemeanors, and the court is also sitting in a circuit court capacity too that has the authority of resolving cases. I just don't understand why now they're bringing this up to preclude us from resolving misdemeanors.
Well, Your Honor, first of all, one, that's not an accurate representation of what happened at the case. What happened was, and I was actually here present in the court when this first appearance, one moment. Judge Imperato placed an order, capias no bond. Defense counsel asked Judge Hurley to set a bond. He did. He then received a call from Judge Imperato advising him, do not change my bond. I didn't give any authority to change my bond. So he put it back at no bond. That's why it's a writ, because the defense had an objection to that, saying that Judge Hurley did change the bond originally, and that's why it's a writ, and it says it's Matta v. Lamberti, and the 4th DCA agreed that he did not have the authority. Resolving the matter, we're not talking about resolving a case. If the court wants to make an offer, we're talking about changing a bond, release conditions. And it doesn't matter if it's it doesn't state that it specifically has to be a capias, a felony. It specifically states The judge that placed the order did not authorize the setting or modification of bail by the judge presiding over the first appearance. And I'm reading directly from the case.
I have to read this case again. It's very short.
Well, Your Honor, I'll wait.
Guys,
I'm going to wait till the court's done. I'm sorry.
All right, so here's my question then.
Yes, Judge.
Did a judge issue this capias?
Yes.
What judge? Do you know?
Your Honor, Judge Hurley, it was from a failure to appear from, one moment. Here, I'll check in Odyssey when the capias was issued. Capias was issued, moment. Looks like, one moment. Looks like it was February 6th. He failed to appear at a status conference on the afternoon of February 6th.
All right. I mean, under this case, I can't amend the bond. I'm texting Judge Hurley to ask if I have permission to alter this bond, and I'll have to put the case on recall. This is the first time I'm actually ever seeing this case. I'm not aware of the case. I'm looking at the plain meaning of it. As long as a judge issued the capias, it appears that the 4th DCA is saying that the first appearance judge does not have authority unless granted by that judge to alter the capias. So I am texting Judge Hurley now to find out if I have his permission to alter this capias. I'll put this on recall, and we'll go from there.
And obviously, and for the record, if Judge Hurley has no objection, then obviously, Your Honor, pursuant to the case, I have no objection.
Right, well, that's what the 4th seems to imply that I need is permission from the judge who issued the capias. I know Judge Hurley. If he doesn't get back to me in a few minutes, I'll call him, and we'll go from there. All right. Okay. Mr. Shade actually just texted me and said 2 minutes, and he's ready on the municipals.
And I don't know.
Okay. Oh, that was in North Broward. Okay. All right, so let me go over to North Broward then. Joseph Bryant. All righty. Good morning, Mr. Bryant. You're charged with aggravated stalking after an injunction for protection of domestic violence and a felony battery.
Yeah, just reviewing, Mr. Did Judge Judge Cohen signed the warrant, right?
No, these are not in custody.
Not custodies.
Judge, the only thing I looked over Mr. I didn't see any. I know I'm not arguing against the aggravated stalking, but the felony battery. I don't know if there was any touching or any physical contact. I don't recall reading that.
It's a filed case. Let me. One moment, Your Honor. Your Honor, there's an additional report.
Is that an odyssey?
No. And as an officer of the court, I'm reading from the report. Just, on September 4th, Brian arrived at the victim's residence, uninvited, demanding entry into the home. The victim advised that she is afraid of Brian and terrified of making him mad, thus she felt obligated to allow him in, hoping that would keep him peaceful. The victim feared that if she waited for police to arrive, he would grow increasingly angry, standing outside and break her windows or damage her property as he has done so in the past. Once inside, the following morning, at approximately 9:40 in the morning, he began questioning the victim about her current romantic relationships. He became enraged, threatened to kill her, and attacked her physically. He used anything he could find to strike her repeatedly. Allegations of a chair, loaded plastic bin, and a large brick. In the midst of the altercation, he grabbed her by the throat and attempted to choke her, although she did not lose the ability to breathe and was able to fight him off. She was also dragged on the floor and kicked in the mouth, resulting in swollen, bleeding lips.
Okay. All right, then I'm going to find probable cause for both counts. Does he have any priors?
Well, Your Honor, counts 1 and 2, he was arrested on a warrant for aggravated assault with a deadly weapon and possession of firearm or ammunition by a convicted felon. He's got a $35,000 bond with the GPS. That's against the different alleged victims where he allegedly threatened two individuals with a firearm pointed directly into the stomach of one of the alleged victims while making further threats and demands.
All right, Mr. Absol?
Judge, he's been living in Fort Lauderdale, Florida all his life prior to his incarceration. I believe he's been in custody since October, and he was kind of surprised because these charges came up, so I had to explain to him what was going on. He doesn't have much money in the bank. He does have a place to reside in Fort Lauderdale. He lives with his family. He supported his family trying to do mobile detailing. There's not much he can afford. He can't afford the counts 1 and 2. I would just ask the court. He is represented by the public defender's office. I would ask the court to set a reasonable bond on counts 3 and 4.
And Your Honor, I can advise the court he was arrested in 2015 for 2 counts of domestic violence battery by strangulation and burglary of a dwelling with battery against the same alleged victim as the ag stalking case. The charges were dropped.
All right. I'm going to set a $10,000 bond on count 3, a $5,000 bond on count 4. Pretrial release level 2 with a GPS monitor on these cases. So you're going to have no contact with the alleged victim. Stay 500 feet away. Don't call, text, write, email, or try to find her on social media. Do you understand?
Yes, sir.
All right. Let me call Mr.
Yes.
Steve, I'm going to get to you in 1 second. Let me call Mr. Johnson back up.
Mr. Scott Johnson's here, present, Judge.
All right, Mr. Johnson, I've spoken with Judge Hurley. I'm going to release you on your recognizance on this case. You've got a status hearing with him on February 20th at 1:30 p.m. Judge Hurley and I communicated via text message, and he has authorized me to issue that release on his capias, okay?
Thank you very much, Judge.
Good luck to you. All right, Steve, let's do the municipals. All right, good morning, by the way. Good
morning,
Nice
how are you?
trip. Had a good trip?
Yeah, a great trip.
Good, good. Welcome back. All right, Ronnie Hamby.
Mr. Hamby, come on up.
Step outside. No, you're
There, sir.
All right, good morning, Mr. Hamby.
okay.
You're charged, you're being held on a misdemeanor warrant. It's a violation of a municipal ordinance of the city of Hollywood. The charge is trespassing on private property. I'm going to appoint an attorney to represent you. His name is Stephen Shate, and he's here with me today. All right, since this is private property, let me take a look at the report. All right, what are his priors look like? 14100. Loitering in front of a business, allegedly.
Last arrest in Broward was in 2011.
All right. Mr. Hamby, if you want to plead no contest to the charge today, I'll withhold adjudication and you'll have a year to pay some court costs. You want to do that?
Yes, sir.
All right, go ahead and raise your right hand. Do you swear? Actually, the other hand. Other hand. Oh, there you
Yeah,
go.
oh, excuse me,
Do you swear? That's okay. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down and tell me your full name, please.
Ronnie Dale Hamby.
Mr. Hamby, you've been charged with trespassing. How do you wish to plead to that offense? Do you want to plead no
Guilty.
contest?
Yes.
Do you understand that by pleading no contest, you're giving up your right to have a trial?
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it difficult for you to understand me today?
No, sir.
All right. I'm going to find your plea to be knowing, intelligent, and voluntary. I'm going to withhold adjudication. You're going to have a year to pay some court costs, okay?
Yes, sir.
All right. Good luck to you. You're all done, sir. Scott Johnson.
Mr. Scott Johnson, come on up, please.
Yeah, why don't you come by here before?
All right, Mr. Johnson, you've got two charges of trespass and a violation of a municipal ordinance of the city of Oakland Park. I'm going to appoint an attorney to represent you on the municipal ordinance violation. His name is Stephen Shade, and he's here with me. I'm going to find probable cause for the offenses. What are his priors? 113056?
No prior Broward arrests.
All right. If you want to plead no contest to both charges today, sir, I'll withhold adjudication, and you'll have a year to pay some court costs. Do you want to do that?
Yes, sir.
All right. Go ahead and raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Put your hand in and tell me your full name, please.
Scott Norman Johnston.
Mr. Johnston, you've been charged with a trespass and a violation of an open container of alcohol law. How do you plead to those offenses?
I'm guilty, sir.
I'll accept the plea of no contest, but I need to know if you understand that by pleading no contest, you're giving up your right to have a trial.
Yes, sir.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it difficult for you to understand me today?
No, sir.
All right, I find your plea to be knowing, intelligent, and voluntary. I'm going to withhold adjudication. You'll have a year to pay some court costs. It says that when they found you, you were drinking a beer and reading a book. What book was it? Do you remember?
It was a Clive Cussler book, The Treasure.
All right, good book. I like Clive Cussler. Anything I can do to help you out? Do you need a place to go for the night?
No, sir. Actually, I'm going to go live with my niece who lives here in town.
Oh, good. All right, that's good. Then good luck to you. All right.
Thank you, sir.
What'd you say? Both counts resolved. Yeah, both counts resolved.
Let's see how this works.
All right, good luck. Good luck. All right. I got 2 more municipal ordinances. Mr. Shade had to go, but I'm going to just handle them real quick. We'll see what they want to do. Robert Kern.
Judge, I've been advised Mr. Kern is a medical reset.
Okay. He really can't come up because if he doesn't come, well, yeah, all right. Medical reset's okay. Med reset, Saturday a.m.
No. Something else.
And what about Diego Rocha?
Mr. Diego Rocha, come on up, please.
All right, Mr. Rocha, you've been charged with a violation of a municipal ordinance that's sleeping in the open. You're also being held on 2 misdemeanor warrants. The charges are resisting without violence and a petty theft. I'm going to find probable cause. I'm going to appoint an attorney to represent you on the municipal case. His name is Stephen Shate. I'm going to release you on your recognizance on that charge. The bonds on counts 2 and 3 are $1,000 on count 2 and $500 on count 3. You're going to see Judge Hurley on February 20th at 1:30 p.m. And Mr. Shate, if they're going to address the municipal ordinance that day, will be with you as well. Okay?
Thank you, Judge.
All right, good luck to you, sir. All right, that should cover the municipals now. You said you were ready for Miss Corbett, right? All right, Stephanie Corbett?
Yes, sir.
All right. Good morning, Miss Corbett.
Good morning.
You're charged with unlawful possession of a personal ID of another, possession of counterfeit driver's license or ID, strong-arm robbery, and a probation or community control violation. I'm going to find probable cause for the offenses. Let's see. The probation is out of Marion County for driving with a suspended license, a felony level. Do you have any other priors?
2012 grand theft.
All right, Mr. Opsell?
Judge, she's a resident of West Palm Beach, Florida. She's been living 3 years in an apartment. She lives with her boyfriend and 5 kids who are currently in school. Her aunt is a nurse. She helps her out. Her aunt gives her about $300 a week, but she just recently paid rent, so she doesn't have any money to bond out with. She'd be relying on her boyfriend to post bond. I would ask the court to set a $2,500 bond on count 3.
And I'm sorry, Judge, and I would be asking for a higher bond. Last year, she was picked up in Marion County on a failure to appear in court. She's had resisting without violence out of Ocala, 2015. Picked up in Leon County in 2013 on a failure to appear on a grand theft. Public assistance fraud, 2013 out of Palm Beach County. She violated probation out of St. Lucie case, 2012. Theft, Boynton Beach, 2010. End of record.
All right. As no monetary charge on count 1, there's a $1,000 bond on count 2. I'm going to set a $5,000 bond count 3. There's no bond on count 4, which is your probation violation. You'll be brought back to Marion after you resolve the charges in this Broward County to face the probation violation. You're to have no contact with the alleged victim. Don't call, text, write, email, or try to find him on social media. Stay at least 500 feet away. Do you understand, ma'am?
Yes, sir.
All right. All right, very good. Wayne, you here on a case?
No, this young lady I ran into, and I just.
All right. He's next.
Sure. Yes, ma'am.
On which
Okay, ma'am.
he was. They're not all municipals. The first one was a municipal.
Okay, ma'am. Thanks a lot. Have a good one.
Wait now. Oh, he had a state trespass and a municipal, right? Yeah, they were both resolved.
Okay,
Both resolved.
thanks.
Okay. All right. Now Leroy Lake Jr.
Can you hear me? Oh, sorry.
Leroy Lake Jr.
I'm sorry?
Oh no.
Oh, okay.
Are you're here on that case?
Yes, sir.
Okay. Good. All right. All right, sir. You're charged with petty theft in the first degree. I'm going to find probable cause for that offense. Ma'am, what's your name?
Cynthia Marshall.
All right. How are you related to Mr.
We're just
Lake?
boyfriend,
Boyfriend,
for
girlfriend?
Over a year, yeah.
Okay. All right. Mr. Linder, any priors?
2014, resisting with violence, 3 counts of battery on a law enforcement officer, 1 count of solicitation on a felony with a violation of probation, possession of marijuana 03, disorderly conduct 01 out of New York. One moment, Judge. End of record, Your Honor.
All right. What did you want to tell me about him? About Lake?
She's just a really good person, and I don't know what happened yesterday, but
You guys live together?
yes.
Sometimes?
Yeah, we're together. It's just we're actually living on someone's couch right now, so we're trying to find a place and get our life together. It's been really difficult.
Either of you working?
I am on and off. I'm an intern private investigator for McKinnon Investigations, and I'm just not working at this moment. I'm trying to find some work.
You think you can afford a $25 bond?
I don't. I have about $18 on me. That's all I have.
All right. I'll release him on his recognizance.
Thank you, sir. Thank you so much.
All right, Mr. Lake, you understand you have to come back and face the charges, right? It's going to be another court date. All right. All right. Good luck to you, sir. You'll be released today. All right.
Thank you, Judge.
Jose, you want me to? You need a few minutes, or?
When to pick him up?
You need a few minutes, Mr. Reyes, or? You sure? Yes, sir. All right. You know, I kind of had a feeling about this one yesterday. That's sort of why I asked you.
Okay, so I can just wait over there.
All right, Mr. Jason Martinez.
Mr. Martinez, come on up. Jason Martinez.
Which one?
Jason Martinez?
He's coming up, Judge.
All right.
Does he need an interpreter?
No.
Okay.
All right, so Mr. Martinez, we met yesterday. So there's been some conversation with Mr. Gottlieb's office. At this point, sir, I know your family is talking to his office, but they have not retained him yet. Mr. Reyes is here today from the Public Defender's Office. He's a homicide public defender, very experienced in these matters. He's appeared before me before. He knows what he's talking about. You have a right to a speedy first appearance within 24 hours of your arrest. You had asked me yesterday if we could hold this off to Monday so your family could retain Mr. Gottlieb.
Okay, I'm going to take these guys back.
It's really up to you, and you can speak to Mr. Reyes on the phone before you make any decisions on what you want to do. Under the law, unless you waive it, you have a right to be heard within 24 hours of your arrest.
Can I speak to him for 1 second, Judge?
Yeah.
Your Honor, I just want to...
Good morning, Mr. Martinez. You can always hire Mr. Gottlieb down the road if you can raise the money. If you can't, I'm prepared to argue for you today. Come see you at the jail and introduce myself later today. And you can always hire Mr. Gottlieb. Today I'm going to ask the court to find that the proof is not evident and the presumption is not great, and that you should not be held on a no bond hold unless there's a proper Arthur hearing conducted where we do a motion to set bond on your case and the court makes findings that are beyond a reasonable doubt. And we call that standard proof evident and beyond a reasonable doubt. No, whatever's in Arthur, Judge. I'm blanking out.
Proof evident, presumption grade.
Thank you, Your Honor. And that's all the legal argument I wanted to make to the court today. And Hector, tell him I'll be over to see him later this afternoon.
So what do you want to do, Mr. Martinez?
The judge is asking you a question. He said he'll come over later on to meet with you. He's saying that your family has basically been in contact with Mr. Gottlieb, but at this point, officially, they have not retained him. So at this point, if you wanted to apply for a public defender, Mr. Reyes would be representing you. And if in the future, let's say on next week, your family retains Mr. Gottlieb, he would substitute in. So the court is asking you, what do you want to do?
Can I retain Gottlieb?
All right. If you are waiving your right to the 24-hour first appearance, I'll reset the case for Monday. Again, I'll say it again. You have a very highly experienced public defender here today, Mr. Reyes. I know him.
So that's fine.
He's highly experienced
Okay.
in the law. Do you want to proceed today, or?
You said, what should I do?
No, you have to make the decision. The judge is giving you right now the option. You have to tell him what you want to do.
I really wanted to go to this way Gottlieb.
Just let the judge know.
I wanted to retain my lawyer first.
Okay.
Your Honor, I understand. For the record, I'm going to be objecting, and I'm pulling the rules of criminal procedure. And I don't believe. One moment, Your Honor. I want to pull the rule that deals with this issue specifically.
What's you have Mike Gottlieb's cell phone number?
Bracket 1, 2, 3.
Hold off for a second, Mr. Liddard. Okay, we're back on the record. I understand, Mr. Martinez, that you want the public defender, Mr. Reyes, to represent you for today at least.
Yes, please. Thank you.
All right, very good.
I'm asking the judge to let you out. There's not enough evidence. Okay, he's going to make a ruling now.
Well,
okay, Mr. Linder.
First, Your Honor, I don't believe in this situation the court needs to reach that determination. I provided the court already with Matta v. Lamberti 993 Southern 2nd, 642. I provided counsel with a copy. I've also provided Your Honor and counsel with a copy of the true bill indicting Mr. Martinez for first-degree murder, signed by the jury foreperson and signed by the circuit judge that presided over the grand jury, also ordering him to be held no bond. Your Honor, I reviewed the true bill. There's nothing indicating in the true bill giving respectfully the first appearance judge authority to modify that no bond hold. So I would argue, also I would note, Your Honor, that a governor's warrant was issued. My understanding, I spoke with Assistant State Attorney Laney Bandel, who's handling this matter. Mr. Martinez fought extradition from New York, and Governor Scott actually issued a governor's warrant extraditing him to face this charge, Your Honor. So my first argument would be that on Matta v. Lamberti, the no bond hold should be kept in place. If the court does not agree with the state's position on that, I would argue, one, we would be seeking a no bond hold. Your Honor, we would, one, find that there is probable cause based on Judge Williams finding and signing the warrant to arrest. Additionally, Your Honor, we would argue that there is proof evident or presumption great for the purposes of first appearance, relying on the warrant affidavit.
Mr. Reyes?
The last thing I would say, Judge, is that that's a very high burden. It doesn't change from day to day. It's still proof evident, presumption great. So I believe that some court has to have a real Arthur hearing almost immediately, and that's why there's other cases that are going to be not as serious as this one, Judge, where there's a no bond hold, and it's going to become critical getting an early determination that gets over that incredibly high bar that's so much higher than our beyond a reasonable doubt burden. So we're asking the court to consider setting an immediate Arthur hearing and giving him a reasonable bond.
Okay. I have to agree with the state here. I don't even think we get there because of the Matta case, and I couldn't even contact Judge Williams right now if I wanted to. He suffered a tragedy and personally, and he's not available, so I could ask him if he.
Well, Your Honor, if I can note for the record two things. One, I'm relying upon the circuit judge's order on the true bill.
Oh, the true bill of the
which was signed after Judge Williams signed the arrest warrant affidavit. And frankly, Your Honor, I would imagine it's within the court's discretion, but I would ask, it's one thing on a misdemeanor capias, Your Honor, on an offense this serious, I would ask, since the court did not put anything indicating there's authorization to modify, I would ask the court, based on Matta, to keep that no bond hold in place.
Yeah. And Mr. Reyes is doing a very good job on your behalf, and he's making very good arguments. However, I am going to keep the no bond hold in place. And if the public defender's office, or if you do wind up hiring a private attorney, can seek a full Arthur hearing before your assigned division judge. Anyway, is that been assigned yet? Since it's been through, Bill?
Yes, Your Honor, it has.
Judge, can I ask the court one favor?
Yes, of course.
You'll save me an hour if you tell the bailiff over there that I want to run over and give the gentleman my business card.
That's no problem.
And Hector, keep him in that room, okay? I'll be there in 5 minutes.
Deputy, Mr. Reyes. Mr. Reyes is.
Deputy.
They have to come to the interview. No, I'm not coming up to. They have to go.
Mr. Judge, I believe the deputies are saying they will not be able to do so.
I did.
You know
Tell
what?
him I did it yesterday. It's silly.
Do you know why, Deputy?
Mr. Martin, Deputy Martin, can you tell the court why? Deputy Martin is approaching, Judge.
Judge, hi. They have to go to the interview room or call above our pay grade. They have to go to the captains or wait to call our lieutenant and go through that.
Are you going to see him this afternoon, or you're going over right now?
I was going to go right now, but tell him I'll see him in the afternoon. I mean, I was over there yesterday. I'm not dangerous. I go through the magnetic thing.
I know you're not dangerous, sir, but last time you said you were going to give him a card and you had a full interview. So
I know. I was there. I sat with him for 10 minutes.
I know, but you were supposed to give him a card, and you did, sir.
All right.
You're going to go see him in the afternoon?
It's okay, Judge.
All right.
I'm a lawyer in the PD's office. We cover that room. They don't understand this.
Right. Deputy, I'm going to order that you let him in. If there's an issue with that, you're going to have the captain call me, okay?
Yes, sir.
All right. All right.
And Your Honor, if I may briefly, Your Honor, I just checked. It appears that the case has not been assigned to a judge.
Okay.
If I may request, on behalf of the state, and I would imagine on Mr. Reyes also, could the court order the clerk's office to expedite issuing a case number so Mr. Reyes can file whatever motions he deems
Thank you, that's a
appropriate
great idea.
as quickly as
I
possible?
thank the state attorney for making that suggestion. I was wondering about that, Judge. I was trying to figure out what division it was.
Yeah.
And it was listing no division.
Yeah,
All
Ms.
right,
Mandel wasn't
I'm
sure
going to order
either,
that the clerk's
so-
office please expedite this. Your supervisor will know how. Yeah. All right.
Tell them to
Ileana's
send
new.
it to Judge Siegel. No. Thank you, Judge.
All right, take care, Jose. All right.
I know.
Yeah,
That's why it's so funny.
Should be attached. Yeah, it should be attached. All right, Vladimir Ortiz. Yeah, Beth will know how. Vladimir Ortiz?
Vladimir Ortiz. What page is he on, Judge? I missed.
He was next up on the, I don't know what page.
It's page 9.
Thank you,
All right.
Mr. Lender.
I didn't say
That's Mr.
Ortiz
Alsop.
has private attorney.
I don't.
Mr. Lender, Mr. Ortiz has private attorney.
Okay. Who's your attorney, sir?
Carlos Fieres.
Carlos Fieres?
Fieres.
Does anybody know him?
I'll check the case. It looks like this was a pretrial release violation warrant.
How do you spell his last name?
FLEITES.
I've got it, Judge.
You got it?
Yeah.
Okay.
Whenever you're ready.
Yeah.
305-672-8434.
Okay. Lietes.
Fieres, yeah.
Yes, good morning. This is Judge Michael Davis, Broward County Courthouse. How are you? I'm doing well. I'm here in a first appearance hearing on one of your clients named Vladimir Ortiz. He's let me know that he's hired Mr. Fleetes to represent him in this case. Is Mr. Fleetes available? That's the case, yeah. That's the one. He was picked up on a misdemeanor warrant on the case. And you can tell Mr. Fleetes, the judge has issued, not me, it's the division judge has issued a no bond hold in the case. So there's not much I'm going to be doing today. He's got a court date with the division judge. It's Division MH. Do you know who that is?
Yes, Your Honor. Judge, it looks like in October, Judge Pohl granted the state's motion to revoke bond and pretrial release. It looks like it says copies are furnished to the state and Mr.
Fleetes.
So
okay. So Mr. Ortiz is going to see Judge Pohl here in Broward on February 14th at 9 to address this. All right? All right. Very good. Thank you so much. All right. Bye-bye now. All right. So, Mr. Ortiz, your attorney's office is aware. They'll be with you on the 14th when you see Judge Pohl. But for now, on Judge Pohl's order, you're going to be held without bond. All right, sir?
Okay.
Good luck to you. Bobby Hash.
Mr. Hodge is here present. Judge, he's asking if you would consider resolving his case for time served.
That's what, Your Honor, just that's what the state would have offered.
Okay. Adjudication time served is
Yes, on
zero?
both counts, yes,
All right.
Judge.
All right, Mr. Haas, so you're being held on 2 misdemeanor warrants for panhandling. The offer is an adjudication and time served and some court costs. Is that what you want to do today?
That's fine.
All right, go ahead and raise your right hand for me. Do you swear and affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I did.
All right, please put your hand down and tell me your full name.
Bobby Eugene Hush.
All right, Mr. Hush, you've been charged with 2 counts of panhandling. How do you plead to those offenses?
No contest.
Do you understand that by pleading no contest, you're giving up your right to have a trial?
Yes.
Are you under the influence of any drugs, alcohol, or prescription medication that would make it difficult for you to understand me today?
Nope.
All right, I'm going to find your plea to be knowing, intelligent, and voluntary. I'm going to find you guilty of the offenses, but I'm going to sentence you to time you've already served, and you'll have a year to pay the court costs. You understand that, sir?
Yes.
All right, good luck to you.
Thank you.
Jesus Martinez.
Mr. Martinez requires Spanish interpreter, Judge.
All right, we will order one.
Thank you.
Rudy Chui?
Mr. Choi is approaching. He's advised if we can confirm that his bond's been posted.
You know, Tanisha? Sir, you've been charged with resisting an officer without violence and petty theft in the second degree. I'll find probable cause. Hasn't been posted yet, but did you contact someone, or you understand someone's contacted someone about posting a bond?
Someone's going to be posting a bond? No one posted it yet, so they are going to go.
When I got locked up, they had my money on me. They said if I had my card, I could give it to them.
Oh, you're going to self-bond?
Oh, he's going to self-bond.
Oh, Judge, he's going to self-bond.
All right, so I'll sign a property order and a $100 bond. Good luck.
Thank you, Judge. Appreciate it.
Joseph Batten.
He just likes to be.
He just needs to tell the deputy he needs to self. Hector, can you tell him that?
Yeah.
He just needs to tell the deputy he's self-bonding.
Where's Mr. Batten?
All right, Joseph Batten.
Mr. Batten, he's not responding. Did he already bond out, Joseph Batten? On page 11.
Well, I'm sure the court remembers Mr. Batten.
Yeah, I do.
Joseph Batten, where are you? Batten!
Did I transfer him to Lerner Wren last time? I don't remember.
I'll check.
Thanks.
Oh, he's the one that...
You guys like him? Oh, now
He's approaching, Judge.
Yeah. I remember. I remember. Yeah. All right. Good morning, Mr. Batten. You're charged with a trespass. I'm going to find probable cause for that offense. I'm going to set the bond at $25, sir. Oop. All right. I really think he needs to be in Judge Lerner Wren. I'm going to...
Follow me.
I'm going to appoint the public defender.
Thank you, Judge.
All right. I know his mental health court is voluntary, and so if he doesn't want to go, all right, I'll just let it go to regular division then. Do what you can for him. Johnny Johnson.
That's North Broward, John.
All right.
Yes, sir.
All right, good morning, Mr. Johnson. You're being held on a misdemeanor warrant for driving with a suspended license. All right, now this was a capias that was issued by the clerk's office, it looks like.
I mean, we have understand that we don't.
Is that right?
I don't know. I have no idea.
Okay, so this capias we can talk about. All right, so Mr. Johnson, driving without suspended license, meaning it wasn't signed by the judge. Right, at a calendar call, something like that.
Yeah, I'm here message until Junior had to come. I got it.
Well, it doesn't have to be felony. It could be misdemeanor also.
Oh, okay.
Like if Judge Hurley, issuing the capias on the earlier case, because it was a no-show at calendar call. All right, let me see.
No, Judge Schiff ordered this capias.
Oh, he did?
Yeah.
All right. All right, then it's a $2,000 bond, sir. Good luck to you.
Judge, if Judge with a court can...
Now that I'm aware of the case, I'll be able to better deal with the issue in the future, and I think I have an idea on how we can get some flexibility. But for today, my hands are a little bit tied. All right, Philip Berdahl.
That's North Broward, Your Honor.
All right, Mr. Berdahl. Good morning. You're charged with battering an officer and resisting an officer with violence. I'm going to find probable cause for the offenses.
He's
No violence.
Sir, I advise you. I told you. I read the report to you. So don't talk about what happened.
Count one, he's being held on a $1,000 bond for felony battery, second or subsequent offense. Count two, he's being held no bond on a VOP for felony battery.
Right, I remember Mr. Berdahl came through the other day. Okay.
Well, Judge, they are.
Yeah, go ahead.
Can I just briefly go off the record? Not off the record, but.
All right, Mr. Berdahl, I'm going to set a $1,000 bond on count 3 and a $1,000 bond on count 4. Good luck. Elijah Bankston.
Mr. Banks is approaching, Judge.
All right, Mr. Bankston, do you want to waive a
We'd
reading?
be waiving formal reading of the
Okay.
charges, Judge.
All right. So, sir, you've been charged with a felony offense. I'm going to find probable cause for that charge. It's count 5. So being held on counts 1 through 4.
Count 1 is a similar offense.
Okay. Different victim?
I can check.
It's okay. Keep going.
2 is either kidnapping or false imprisonment. He's got a parole violation, no bond hold for burglary of an occupied dwelling and grand theft. And, Judge. He's also had grand theft, 88, 5-year state prison. Strong arm robbery, 88, 5.5-year state prison. Possession of cocaine, 85.
All right, Mr. Romero.
Judge, and speaking of Mr. Bankston, he's been residing here his whole life. He is 58 years old. Prior to him being arrested, he was working side jobs, doing car detailing. He would be paid by the vehicle, so his income would fluctuate. Financially, has no money in the bank, no property. He lives in Hallandale. Judge, we'd be asking you to set a reasonable bond.
And, Your Honor, I can tell you, if the court wants to take into consideration, this is a different alleged victim.
Okay. I'm going to set a $150,000 bond on count 5. Sir, you're to have no contact with the alleged victim. Don't call, text, write, email, or try to find her on social media. Stay at least 500 feet away. You understand that, sir?
Yes, sir.
All right, good luck to you. Robert Wells?
No problem.
All right.
North Broward, Judge.
Let me see the stuff right there.
All righty. Mr. Wells, good morning. You're charged with grand theft auto, leaving the scene of a crash involving damage to property, and 2 counts violating your probation or community control. I'm going to find probable cause. Bond on count 1 is $1,000. There's no monetary charge on count 2. There's no bond on counts 3 or 4. You'll see your division judge on February 16th, 8:30 a.m. Good luck, sir.
Count plea, no contest?
Not today, but soon you're going to see your judge, okay? Good luck. Andrew Sentence.
He's approaching, Judge.
Okay. All right, Mr. Sentence, you're charged with violating your felony probation. You're going to be held without bond at this time. You're going to see your division judge, Judge Bailey, on February 14th, 8:30 a.m. Good luck.
Amari Huggins, come on up.
All right, Mr. Huggins, you've been charged with violating your felony probation. You're going to be held without bond at this time. You're going to see your division judge, Judge Usan, February 14th, 9 a.m. Good luck.
Thank you.
Michael Fearman.
North Broward.
All right, Mr. Fearman, good morning. You're charged with a violation of your felony probation. You're going to be held without bond at this time. You're going to see Judge Porter, February 14th, 8:30 a.m. to address the charges. Good luck. Charles Wilson.
I've been advised Charles Wilson bonded, Judge.
Okay. He does have a court date coming up when they bond Ileana. Are they going to keep that court date or are they going to amend it? Do you know?
I think they advise.
They'll advise him and keep it. Okay. All right. Very good. All right. William Richendaler.
Mr. Richendaler is here present, Judge.
All right. Sir, you're charged with dealing in stolen property and providing false information to a pawn owner. I'm going to find probable cause for those offenses. I'll set bond at $3,500 count 1 and $1,000 on count 2. Good luck.
That's it.
Wayne Williamson.
That's somebody else. Mr. Williamson.
Mr. Williamson, good morning. You're charged with possession of cocaine.
Good morning, sir.
Good morning. I'm going to find probable cause, and I'll set bond at $1,000, sir. Good luck.
Thank you. Thank you.
Zachary Moore.
Mr. Moore's coming up.
Oh, it's a municipal. All right. All right, Mr. Moore, you're charged with possession of cocaine, possession of drug paraphernalia, and a misdemeanor warrant on a municipal ordinance for a trespassing. I'm going to find probable cause. On the municipal ordinance, I'm going to appoint an attorney to represent you. His name is Stephen Shate. He'll be with you at the next hearing. I'm going to set bond on count 1 at $1,000. There's no monetary charge on count 2. Count 3 will be a $100 bond. Good luck to you, sir. Johnny Walter.
North Broward.
All righty. Good morning, Mr. Walter. Hey, you're charged.
Good morning, sir.
Good morning. You're charged with 3 counts of delivery of cocaine within 1,000 feet of a school, daycare, or park. I'm going to find probable cause for the offenses, and bond will be $7,500 per count.
Judge, would the court consider reducing one of the counts? I could tell you a little bit about him. He's a resident of Broward County. He's been living here for 3 to 4 years. He was working prior. He recently did lose his job. He lives with his girlfriend in Hollywood.
2 kids.
He has 2 kids. He lives with his girlfriend who works for Hotel Suites. He's going to be relying on her or his mother to bond out. He was in a pretty bad car accident last year where he has metal plate in his legs. He used to work in shipping and receiving. He doesn't have much money in the bank. $1,200 goes to rent. Just asking for a little bit, just a bit of a reduction on one of the counts.
He's currently got a warrant out of Dade County for failing to appear in court on a possession of cannabis case.
All right.
I'm showing in 03, he was sentenced to 3 days in jail for domestic violence battery. Another failure to appear after a written promise in California in 03.
I finished that in California. Everything's done in California. It was old.
All right, well, we got an open warrant at a date. I'm going to keep the bonds as they are. Good luck to you.
How much is the bond?
It's 7,500 times 3.
I'm calling your girlfriend now.
Roderick Bruton. Good luck,
Do
sir.
I stay here?
All right, Mr. Bruton, good morning. You're charged with the grand theft. I'll find probable cause for the offense. Did you verify? Prior grand theft. Got it. All right, sir. It's going to be a $1,000 bond on this count. I'm going to find probable cause. Good luck to you. Yeah, we can do that. Oh, will be pending verification for pretrial. If they can determine where you live, if they can verify it, you can go out on pretrial. Good luck.
Good luck. All right, thanks.
You got it. Daniel McNeely.
Mr. McNeely's here, President Main Judge.
All right. Mr. McNeely, you're charged with 3 counts of possession with intent to sell cannabis within 1,000 feet of a school or park and possession of drug paraphernalia. Bond will be $5,000 on counts 1, 2, and 3, and I'll ROR count 4. Good luck to you.
$500 count 1, 2, and 3? Okay,
No,
perfect.
5,000.
Thank you.
5,000.
Oh,
5,000.
Oh, Judge, and could I be heard then? And speaking of Mr. McNeely, he's been residing here his whole life. He's 27 years old. He's a graduate of Miramar High School in 2008. He attended Broward College. He's self-employed. He's a photographer. His salary fluctuates. Last year was a slow month. He only made $1,000. He has no money in the bank, no property. He lives in Miramar with his mother. He has one child that's 4 years old that he financially supports. He gives the child's mother approximately $300 a month. Judge, what we would be asking for is if you would consider reducing the bonds on 1, 2, and 3 from $5,000 to $2,500 each count. And if the state can verify that he's not a convicted felon, he advised me he's a registered voter.
Your Honor, I don't see a record. I would ask the court, obviously, to take into consideration. I know you were given information about his financial resources, but it would appear from the reports that he also earns money from selling drugs. At least on one of these occasions, he was right next to a child care facility.
All right, I'll ROR count 3, so it's a total $10,000 bond. Good luck.
Thank you, Judge.
Devin Andrews. All right, Mr. Andrews, you've been charged with distribution and delivery of cocaine. I'm going to find probable cause for the offenses. Does he have a record? Any priors?
One moment, Your Honor. This is Mr. Andrews?
Andrews, yep.
Mr. Andrews is currently out of custody on burglary of a structure and grand theft.
Ooh. All right, what's the case number?
16450 CF10A.
All right, sir, I'm revoking your bond in case 16450 CF10A. On this case, it's going to be a $2,500 bond. Good luck to you. Javed Ellis.
Mr. Ellis, come on up, please.
All right, Mr. Ellis, you're charged with 4 counts burglary of an unoccupied conveyance, 1 count of operating a chop shop, 4 counts grand theft. I'm sorry, 5 counts grand theft. I'll find probable cause for the offenses. Does he have any priors?
Does pretrial? I have nothing on him. Does pretrial have anything? Thank you.
All right, Mr. Romero.
As the state verified judge, he has no record. This is his first contact with the criminal justice system. He is working. He works at the car wash. He's been working at the car wash for about 1.5 years. He gets about $10 per car that he washes. Financially, has no money in the bank, no properties. 24 years old. He lives in Hollywood with his girlfriend. He makes approximately, his apartment, his rent is about $1,250. His girlfriend also works, so they both come up with the rent. She's in catering. She makes minimum wage, $8.05. We'd be asking you to set a reasonable bond as to counts 1 and 4 and consider reducing the bonds on counts 6, 7, 8, and 9.
Frankly, Judge, I'm actually more concerned hearing that he works at a car wash, considering what he's here for.
All right, 1 second. All right, $1,000 bond on the burglary counts each. And everything else will remain in place. 1,000 count 5, 5,000 on count 6 through 9, and 1,000 on count 10. No contact with any of the co-defendants or witnesses in this case. Stay 500 feet away. Don't call, text, write, email, or try to find them on social media. Good luck, sir. Ronnie Giles.
Mr. Ronnie Giles, come on up, please.
All right, Mr. Giles, you're charged with a grand theft. I'm going to find probable cause for that offense, and I'll set bond at $1,000, sir. Good luck. All right, we've got the Spanish interpreter. We've got the Spanish interpreter here today. Jesus Martinez.
Ven aquí, por favor.
All right, Esteban, I'm going to swear you in. Do you swear, affirm, to accurately translate from English to Spanish and Spanish to English to the best of your ability?
I do. Esteban Rojas.
All right, very good. Mr. Martinez, you're being held on 2 misdemeanor warrants.
Señor Martínez, usted está detenido por 2 órdenes de arresto que tienen su contra por contravenciones.
Still waiting on that dude to come back or something?
One is for a trespass after warning.
Una es por irrumpir ilegalmente en una propiedad luego de ser advertido de que no lo hiciera.
The second is for disorderly intoxication.
El segundo es por conducta desordenada intoxicada.
The bonds are $500 on count 1
La fianza es de $500 por el primer cargo,
and $100 on count 2.
$100 por el segundo.
You're going to see Judge Brown on February 16th
Le va a tocar comparecer ante la jueza Brown el 16 de febrero
at 10 a.m.
a las 10 de la mañana.
She's out right now too, so I'm not going to be able to get in touch with her.
Judge,
Yes.
I have something to say. In speaking with Mr. Martinez, he's been released from custody. He was in custody in North Broward. He advised me he was released January 30th. If the court date was when he was in custody, and we can verify it, Judge, I would argue it wasn't willful, and I believe we'd be asking you to consider an ROR.
Señor juez, luego de hablar con el señor Martínez me informa que él estuvo en custodia en la cárcel del norte de Broward y el 30 de enero, si nosotros logramos demostrar que esa era su fecha de comparecencia ante la corte, entonces yo argumentaría que eso no fue voluntario, entonces con base en ello solicitaríamos que se le liberara bajo su propia responsabilidad.
Wait.
They're saying it was issued while he was in custody. They're asking for an ROR.
Who is this? Jesus Martinez?
Yeah.
Denise, are you showing his failure to appear was February 7th? He got out of custody January 31st.
If that's the truth, we withdraw that.
Okay. All right. Good.
We have one more over at Conti facility for a second look.
All right. Good luck to you, sir. What's his name?
William Alvarez.
Do you have the second look jackets, Ileana? They didn't give you the second look jackets? They were supposed to have. They didn't give you anything?
We're gonna need it, bro, because we have a 30-day that we have to hear this morning.
Yeah. All right. In the meantime, do you happen to know his case number? I can look up what's going on. This is the second look? 909. Hang on one second. I gotta log in. Okay, what was that case number, folks? 17909. And then 7.
Let's see what I got here. So reset.
Looks like there's a defense motion to reduce bond already signed. Already filed. Count 2 is a municipal ordinance. Reduced his bond as the first appearance to $25. What are his priors?
I need a BCCN number. Eight 56415. Yeah. Sir, if you could. He had an aggravated battery from arrest from last year that was dropped.
Judge, can you,
Que como antecedente tiene un delito de lesiones agravadas producto de un robo el año pasado, sin embargo ese cargo se había retirado.
And a theft that was pled out last year.
Y también un hurto sobre el cual llegó un acuerdo con la fiscalía el año pasado.
I don't know how he's going to get back to court.
No
That
sé,
was the issue. He doesn't have a residence.
no sé cómo va a lograr volver a comparecer ante la corte porque el tema parece ser que no tiene domicilio.
All right, if he wants to take care of both charges today and plead no contest, I'll give him a withhold of adjudication and
Bien,
some
si-
court costs.
Si el acusado desea resolver esos cargos antiguos, hoy le ofrecería un fallo sin condena y costas judiciales.
Okay.
You want to do that, sir?
¿Desea hacer eso, señor?
Sí.
Yes.
All right, go ahead and raise your right hand.
Que levante su mano derecha.
Do you swear or affirm to tell the truth,
Jura o afirma solemnemente decir la verdad,
the whole truth,
toda la verdad,
nothing but the truth?
nada más que la verdad.
So help you God.
Así le ayude Dios.
Sí.
Yes.
All right, put your
Okay.
hand down and tell me your full name.
Baje la mano y dígame su nombre completo.
William Álvarez.
All right, Mr. Alvarez, you've been charged with petty theft.
Bien, señor Álvarez, a usted se le acusa de hurto menor.
Was it open
Uh-huh.
containers?
Well, Your Honor, I don't know offhand, but I'd also ask if that he needs to be advised.
Su señoría, no sé, no tengo el dato justo aquí en este momento, pero el acusado debe saber lo siguiente.
He pled out to one theft last year.
Él llegó a un acuerdo con respecto a un hurto el año pasado.
This would be a second plea to an offense of a crime of moral turpitude or dishonesty.
Esto sería un segundo acuerdo que tiene de por medio un delito de torpeza moral junto con deshonestidad.
Even with a withhold, I don't know if there's going to be any potential consequences if he is not a citizen.
Aún a pesar del hecho de que el fallo es fallo sin condena, no sé si posiblemente hubiera algunas consecuencias migratorias si no es ciudadano.
And if he's going to take a plea today, he needs to be advised of that.
Si va a aceptar un acuerdo hoy, tiene que estar consciente de eso.
Do you understand what the prosecutor said, sir?
¿Entiende lo que dijo el fiscal, señor?
Sí, señor.
Yes, sir.
Do you still want to take a plea to this charge?
¿Aún así desea proceder y llegar a un acuerdo sobre este cargo?
Sí.
Yes.
I just want to advise him that if he takes a plea to this with new, in light of the new executive orders coming down the pipe, that deportation is most likely going to happen if he takes a plea in light of his prior conviction of theft and now taking a plea to this charge. If he's not,
We better send this to division then. I'm going to send this over to Judge Carpenter Toy. I'll keep the bond at $25.
Debido a los temas migratorios de los que tiene que estar consciente, creo que mejor
Right.
voy a mandarlo al juez de la división. Voy a mandar este caso
I understand.
ante la jueza Carpenter Toy.
All right. You'll see the judge next week, okay?
Va a comparecer ante la jueza la próxima semana. ¿Está bien?
Está bien.
All right. Good luck.
Okay. Buena suerte.
Yeah. All right. Good luck, sir.
Buena suerte, señor.
All right. I think that's it for you, Esteban. Thank you so much.
Pleasure.
All right. Kelly Manaxit.
He's here, Judge, at Maine. We'd be asking you to consider reducing the bond by half.
All right. Sir, you're charged with possession of cocaine. I will find probable cause for that offense. Does he have any priors?
One moment, Your Honor. Okay. One moment, Judge. He was arrested 20 days ago for possession of marijuana with intent to sell, deliver, and possession of cocaine with intent to sell, deliver.
All right. I'm gonna keep the bond at 1,000. Good luck to you, sir.
Thank you, Judge.
All righty. Marquise Washington.
Mr. Marquise Washington is here present, Judge?
All right, sir. You're charged with a violation of your parole. You're going to be held without bond at this time. I'm going to find probable cause, and the parole board will come and conduct a hearing with you at the jail. All right, sir? All right. Good luck. Good luck. Thanks so much for bringing those up. We appreciate it. Anthony Sneed.
I believe he bonded, Judge.
All right.
He bonded. Yes, I've been advised he bonded.
All right. I'll find probable cause. Terrence Williams.
North Broward, Your Honor.
All righty.
Right on the X.
18.
All righty.
That's good.
You're good. You're good right there. Mr. Williams, you're charged with 2 counts of selling cocaine within 1,000 feet of a school, daycare, or park. I'm going to find probable cause. I'll set bond at $5,000 per count, sir.
Judge, would the court reduce count 2?
Your Honor. One moment. I'm just checking his record.
Okay.
Just can I ask him a couple questions? I didn't get a chance to talk to him.
Sure.
Sir, do you have someone to pay your bond?
No, sir. I can call a friend. Maybe I can get him to do it to pay the bond.
Where do you live?
I live in Victoria Park, 1721 on 9th Street.
Are you working?
Yes, sir. I work with Devin Next, sir. It's on Sunrise, the Winn-Dixie Plaza near 15th.
Do you have any money?
Yes, sir. Barbershop.
Do you have any money to bond out with, or any?
Well, I mean,
Yes.
I have an apartment that I pay $1,200 a rent a month. I'm supposed to pick up my deposit, but however, that'll be impossible trying to contact my landlord so that I can do that to get out.
Judge, I would at least the court just count 2. I would ask the court to reduce that.
I'm asking for bond increases. 1994, second-degree murder out of Broward, sentenced to 21 years state prison. He was released July 19, 2011.
Well,
there wasn't no self-defense.
Sir, it's from 94, Judge.
All right. I'm gonna keep the bonds as they are. 5,000 per count. Good luck, sir. Michael Bixby.
You might be doing a finger there.
Is that still a medical reset?
No, he's at North Broward, Your Honor. He's coming.
Okie dokie.
He's in a wheelchair. How much is
All right, no problem.
5,000 for each count. There's 2 counts. Yeah. 4,000, so I gotta pay 10% back, which is 1,000.
All right. Good morning, Mr. Bixby. You're charged with criminal mischief over $1,000. I'm going to find probable cause for the offense, sir. I'm going to set bond at $500. Good luck.
No victim contact, Judge?
Yeah, no contact with the victim, sir. You got to stay 500 feet away. Don't call, text, write, or try to find him on social media. Good luck. All right. Was Terry Whetstone able to be brought up today?
Judge, I'm going to waive his appearance.
Okay. I understand.
Your Honor,
yes.
I'm going to ask again that this matter be left to Judge Fine. I spoke with Judge Fine's prosecutor that would be handling this case. She was aware of the arraignment. She spoke to Judge Fine. He has no problem having any bond issues being brought before him, and I can contact the ASA to seek to have it set as quickly as possible.
Judge, just brief response. It's our position that the fact that unless there's a finding of proof, evident, presumption great, or the state intends to file a motion within 3 days if they're moving for pretrial detention, that his detention in our position is unlawful without a bond being set. Well, I was asking for reasonable conditions as to his bond. He is medically sick. He was unable to make it. For this hearing, I'm waiving his appearance. The state hasn't indicated that prior to his arraignment or his next court date, they're going to file a motion for pretrial detention. The next step is for them to establish proof, evident, presumption great, which is a burden higher than beyond a reasonable doubt, which they have to establish. I would ask the court to set a reasonable bond in his case and have the state prove their burden.
And Your Honor, I just want to clarify something in the record, because what I've been advised is that the defendant has routinely been refusing to come to court. He actually refused to come to his arraignment. Judge Fine ordered to have him brought. They brought him. They had the arraignment. There were no issues. Your Honor, also, the state's position is this isn't a matter of proof evident or presumption great at this time. It's a matter of that since he's been arraigned, any bond decisions, matter of fact, any legal decisions on this case needs to be made by Judge Fine.
I agree. I'm going to authorize that he be held no bond at this time, and any bond matters will be heard before Judge Fine. And I want you both to work on having this set before Judge Fine as quickly as possible.
I will contact the ASA that's handling the case and advise her that she needs to have it set, Your Honor.
All right, sounds good. And Matthew Danchek?
Did he post by any chance?
Maybe he posted bond.
I know his attorney was here yesterday morning. He bonded?
He posted?
All right.
All right. Now, find probable cause.
And we have a perfection judge.
Oh, yeah, right. We do have a perfection for
Conti?
Malik Cal.
Yeah.
Malik Cam.
Your Honor, I've provided a supplement. I think this takes care of any issues the defense had. Yeah, it's being given to you right now, Judge.
Okay.
Not only connecting the property that was sold at the pawn shop to the property that was stolen from the burglary, but also linking Mr. Ham to the home where the property was stolen from.
Okay. All right. Then I'm going to find probable cause for all three charges, counts 5, 6, and 7 of burglary, of an unoccupied dwelling, grand theft, and dealing in stolen property. I'll set the bond at count 5 at $3,500, count 6 $1,000, count 7 $3,500.
Your Honor, just
Yeah.
one moment. Your Honor, and I didn't bring this up yesterday because I didn't know if PC would be found or not. 2 weeks before this alleged incident, Mr. Ham posted bond on a grand theft auto. We also filed a charge of resisting without violence. Charges have been filed and they are pending right now before Judge Fine.
All right. I'm going to revoke bond in that case. What's the case number?
Oh, is he being held on? Yes, I apologize. Is he being held on those?
He's already being held on them?
Okay, never mind.
All right.
Not
Well-
no bond. He's being held because it was a violation of pretrial warrant for that case.
And
The bond is $2,500 for the grand theft.
Okay.
All right, so
Well, then,
Judge
yeah,
Fine
I'm not-
set
yeah,
the bonds.
yeah.
All right. So you're going to have no contact with the alleged victims in this case. Don't call, text, write, email, or try to find them on social media. Stay at least 500 feet away. Do you understand? All right. Good luck,
Yes.
sir. And do we only have one 30 day? Just one? 3,500, and then the stand, whatever was in place, the standards.
The last guy's at Conti, Your Honor.
Yes. Send him to division. I can't. No action. No action. Yeah, because there were some potential immigration issues. All right, you're Alexis Salmon, sir.
Yes, sir.
All right. All right.
Your Honor, I believe this was filed like maybe 2 days ago. I'll confirm.
All right. Double check.
Yes. Information was filed February 8th. He is scheduled for, I'm sorry. Yeah, he is scheduled for arraignment before Judge Scher February 15th at 8:45 in the morning.
All right. All right, sir. So your motion for release is denied today. You're going to see Judge Scher in a bit for an arraignment very soon, okay?
Thank you.
All right. Good luck to you. All right. Thanks, everybody, and have a great day.